Welcome back to Sunrise Daily. They call them Lionel Silk. One of them joins us this morning. Ikaso Akariwe, Senior Advocate of Nigeria, former First Vice President of the NBA and convener, We the People. Good morning and thank you for joining us on the program today, sir.
Good morning.
Permit me to start on this part where we left off with Honorable Togoa, this clause, because you say justice must not just be done, must be seen to have been done. So if we, the people, are seeing something else, I think you come in rightly so to help us interpret. So give us your understanding of that section 63 of the Electoral Act, because he thinks, I'm sure, I don't know how much of that interview you caught, where he thinks that, nope, is the responsibility of the voter to also ensure that their ballot papers are stamped and signed and not just to cast their vote. But we read the point of the law, but he thinks differently in terms of interpretation.
The language of Section 63 is clear. And I don't think that the voter has a responsibility to insist on the ballot being stamped by INEC. As a matter of fact, you read out the statute which stated clearly that INEC had a discretion whether to accept a ballot which is not marked by them, which is not stamped by them or not. And I would have thought that INEC would exercise her discretion in favor of the ballots, whether they are stamped or not, because failure to stamp the ballot is not the fault of the voter, but is the fault of the INEC staff. And to refuse to accept a paper because it was not stamped amounts to punishing the voter for the failure of INEC, unless they are able to prove, I'm reading that now. If the returning officer is satisfied that a ballot paper which does not bear the official mark was from a book of ballot papers which was furnished to the presiding officer of the polling unit in which the vote was cast for use at the election in question, he or she shall, notwithstanding the absence of the official mark, count the paper. I think it speaks for itself. Is the paper from the bundle of the papers meant for the election? Unless INEC is able to prove, or the person who is disagreeing with the credibility of the election is able to prove that the papers which were cast in the elections did not emanate from the bundle, from the INEC bundle. I can imagine that the papers, the ballots are numbered. You will find 0028, 0029, 0030, and so on and so forth. So if 0028 was stamped and 0029 was not stamped or marked, and 0030 was not stamped or marked, but 0031 was stamped or marked, why would INEC reject the paper? And why will the burden be placed upon the poor voter? In the culture we come from, the diverse agglomeration of cultures in Nigeria, can you imagine a woman voter, particularly in the rural areas, particularly in the parts of Nigeria where females are really meant to be seen and not heard? There are some parts of Nigeria like that. Can you imagine a lady voter insisting or quarreling with INEC? You must mark the ballots I used. So I don't agree at all, with the greatest respect, with Honorable Togoa, that it was the duty of the voters to insist that it should be stamped. I think that it was the duty of INEC to try its utmost to give effect to the will of the people. And by so saying, I mean INEC should simply have ensured that whether there was a mark, their own mark or not on the ballots, they would look to see if the ballots emanated from their bundle. And if numbers 2 and 3-1 didn't have marks and 3-2 and 3-3 had marks, it's from their bundle, and they ought to give it a pass mark.
All right.
But as it is, INEC, with the greatest respect, it is my humble view, and it does appear to me that they willy-nilly failed in that respect. They just rejected every ballot that didn't have their mark, whereas it was their own fault. So they punished the voter for the mistakes of their own staff. That's not fair.
So INEC counted the ballot, but the courts deducted the votes and gave victory to the APC in that kind of case. But that takes us then to the narratives that came through from the CJN in light of some of these judgments that come through and the way people are internalizing those judgments. Because he then said, one of the dailies quoted him saying, look, we cannot replace law with emotion. But today, we did see the AGF also quoted to have said, we will do our best to reform the judiciary. So it sends two separate messages. For that of the CJN, so when people say that, that sounded defiant, because, I mean, members of the public have a right to air their opinion about what they think about those judgments. So when he then says, we cannot replace the law with emotion, how does that sit with you?
Before I comment on that, just permit me, please, to comment on what we just discussed. You pointed out to me that INEC actually approved of those votes, but it was the court that deducted those votes. In that scenario, I will have to respectfully disagree with the court. Unless INEC was not able to prove at the tribunal that, hey, the ballots did not emanate from the bundle of ballots which we issued. If INEC was able to prove that, if that was an issue in the lower court, then with the greatest respect, I would have to disagree with the decision of the Court of Appeal in Kano Division. Now, going to what my Lord, the Chief Justice, Honorable Justice Aruola said, and I must say that he is a jurist I respect most highly. He sat in the Enugu Division of the Court of Appeal as the presiding justice. Enugu is where I have my primary law practice, and he acquitted himself honorably while he was here, and he's presiding over the judiciary in Nigeria at a crucial and critical time. However, what I would say is, yes, law must be given credence to and not emotions. Sometimes the jurist looks at the letter of the law and even tries to look at the spirit of the law, and then the preponderant view out there on the streets is not in accord with the letter of the law. What does the jurist do? Does he follow the emotion? Does he even follow his own emotions? Perhaps the jurist is of the private view that this is the way it should have been, but this is what the law says. The law is a certainty. The law gives certainty. The letter of the law gives certainty. But what we ask jurists to do is don't just look at the letter of the law, look at the spirit of the law. So sometimes when you try to look at what was the guiding philosophy behind that law, because strictly following the letter of the law may bring us to the position of Shiloh, who was asking for a pound of flesh without shedding a liter of blood. There's no way you are going to cut off my pound of flesh, because that is what the law says, and I won't shed blood. So my humble suggestion, and I think this should be presented to the College of Judges as they meet in their various meetings, the spirit of the law, and that, by that I mean the guiding philosophy. Why was such a law made? Sometimes when you read the Electoral Act, you can see what the lawmakers were running from or running to because of experience in past years. Indeed, Honorable Doguwa referred to the possibility of further amendments given the scenarios, unpleasant scenarios, which emerged out of the immediate last elections.
Well, this last elections, the judgments that have come out, some of the disputes that have been raised will continue to remain an emotional matter for many people. When you look at the statement of His Lordship, the Chief Justice of Nigeria, how did you as a lawyer, especially as a senior advocate of Nigeria, internalize it?
Well, I was right there in the Supreme Court the day before yesterday as he delivered his speech, and listening to him, it was a robust, unapologetic assessment of the judiciary. He did say that as a matter of fact, the Nigerian judiciary was doing very well and counted among the best in the world, and there was absolutely no reason for people to worry about it. And I was impressed with the feistiness of his speech. Definitely, he was trying to encourage and comfort both the justices who have received quite a bit of blows in the last couple of months, and trying to also rekindle the confidence of Nigerians in the judiciary. But I would still want to request, with the greatest respect, that perception being reality, what I perceive is my reality, however stupid I might be, it is important for the judiciary at the Supreme Court level to enlarge the activities of the public relations department, the publicity department. Nigerians don't understand the way the judiciary works. Nigerians don't understand the principle of stare decisis, which means that the lower court must follow the path of the upper court, the higher court. Nigerians do not understand that the judiciary must follow law and not emotions, even though I would put a caveat to that. I would suggest that the judiciary will of course not just follow the letter of the law, but will seek to know the guiding philosophy behind the law and give effect, just in case the draftsman has been clumsy in putting together the words. So there's a need for the judiciary to engage more with the people of Nigeria, not by the Chief Justice addressing every issue, but by a robust, enlarged public relations department, not only at the Supreme Court, at the Court of Appeal, Federal High Court, and the High Courts too. A couple of years ago, I was at the legal year opening ceremony of the Supreme Court of the UK and Wales, of the UK, England and Wales. And I was amazed when I went into the Supreme Court and saw that the distance between where the justices of the Supreme Court sat and where the lawyer sits opposite them was barely about, maybe, shall I say, 4 feet, maybe 3 feet. So I said to them, I said to the officer of the court who was showing us around, I said, this is unusual. Why would the justices sit so near the lawyers? I said, in my country, they sit far away and they are elevated. They sit on an elevated dais. And the gentleman said to us, the reason we put their chairs, their tables and chairs closer to the bar is to demystify the court. We want to make the court more interactive. We want to remove fear and intimidation. That was very instructive to me. And in fact, we also saw cameras in the court so that they could, so that the public can follow the proceedings of any matters when the public are interested or the public clamor to be televised live. I think that gone are the days when we say judges don't speak for themselves. The court is like a masquerade. The court is mysterious and mystified. I think that the reality of democracy and the reality of the current wind of opinion in the public is that we should open up the court a little. Let a robust, not the judges, a robust public relations department. And my good friend, Dr. Akonde, is doing a good job at the Supreme Court, but only within the circumference he has to operate in. There's need for the Supreme Court to become more open in the court of appeal. There's need for somebody to come out every day and address a press conference after important judgment and break down the judgment to the public in simplified English, so the people can understand the reasoning, how the court works. Nigerians are much more educated now than before, and democracy has made even the person selling cola nut to follow events. They listen to radio. Everybody's listening, watching the TV. My 88-year-old mother asked me questions, deep questions about the things going on in the country.
It's a very interesting proposition you make. I'm sure my colleagues will have more questions for you. Hi, Dayan Bukola.
Well, thanks a lot, Mark. And I think it was the Attorney General of the Federation, right, who was saying recently about some people who have disagreed with the courts, criticized the judgments and all. And he was of the opinion that this might just be denigrating the nation Nigeria. And I'd like you to speak to that. As Chamberlain was saying earlier on, it's not enough for justice to be done. It is said that justice must also be seen to be done. But for the majority of people who say, well, we don't see justice being done, we see hanky-panky here. Yes, we respect the judiciary because of the role it plays in the democracy that we're fighting for, but we don't see things going right.
The audio is rather low. Please, if you don't mind, could you repeat it? I'd like more audio.
Right, no problem. My question essentially is around what the Attorney General of the Federation said recently, that those who are criticizing the courts, who disagree with the courts, might just be denigrating Nigeria as a nation, and he believes that that is not good for the image of the nation, not just here, but outside. I wonder what your thoughts are. How do you ensure that you hold the judiciary accountable, but still protect the image, as it were, of Nigeria?
I would like to think that what the Attorney General of the Federation was saying is with respect to the immediate past IBA, International Bar Association Conference in France, where some Nigerian lawyers got up at one of the sessions. I think it was the rule of law session, I can't swear, and they were criticizing our judiciary, the appointment process and judgments. The president of the Nigerian Bar Association also referred to it. I do not think the Attorney General meant to say that Nigerians should not criticize the judiciary and judgments because it's part of the game. Judgments are critiqued. We have journals where we critique judgments. Nothing wrong with a Nigerian standing up in the press, going to the press to disagree with a judgment, as long as he does that with decent language, not abusive language. And I do not see how the judiciary is denigrated in the eyes of the foreign world if within Nigeria we are critiquing our judgments. But I would like to think that the Attorney General was referring to the immediate past International Bar Association Conference, which ended not up to 1 month ago, where Nigerian lawyers, in the full view of the public, were criticizing the judgment. I think his concern was, do not wash your dirty linens in public. And what do I think about that? I would like to think that, yes, there's something a little bit off about going to an international forum to criticize your judgments and your judges and how you appoint your judges. But I would also like to think that when it becomes well nigh impossible to get change locally, sometimes people go outside in the hope of getting some help from outside, even though I don't know what sort of help we can get from the international community. I think we can probably help ourselves more within the country.
Right, let me just quickly follow up with this one. It will seem, again, people agree that there's some dirty linen to be washed. The question is maybe where do we wash it, how do we wash it, but at least we agree that we need to wash the linen. The Labour Party recently, I think it was yesterday, put out a statement saying that, well, it looks like the Supreme Court did not particularly rule on its own case. It says that it appears the Supreme Court lumped it together with the PDP's case. I don't know if you've come across that statement. In fact, the Labour Party said they had written to the court to get certified true copies. They had not gotten it. And again, for them and their supporters who have been clamoring or at least saying they suspect foul play, it looks like another, justification for that suspicion. Is that right? Have you been following that case, if I may ask?
Yes, beginning with your opening remarks, yes, there are dirty linens to be washed in every sector of the country, even in America, in the UK, Ghana. And where do we wash our dirty linens? Well, let's wash our dirty linen within the privacy of Nigeria. Let us write petitions. Let us, like President YC Mikiao said, if you have proof of corruption, if you have proof of wrongdoing, bring it forth. Do an affidavit, bring it forth, and see if it will not be investigated. I think that we will need to stop running with rumors and insist that those who give us information should give us proof, and we need to depose affidavits with proof and insist that the regulatory authorities act on our proof. And if they fail to act on our proof, then we know that the regulatory authorities are wanted on their jobs, and perhaps only then can we step outside the country in lawyers' fora abroad and begin to complain. As for the Labour Party and its recently issued statement stating that judgment was not delivered in their matter, but was delivered only in the PDP matter. Honestly, I need to digest that very well, but it seems to be interesting. I found it interesting when the statement began to make the rounds yesterday. Do I have an opinion of it? Not yet. It just seems a bit shocking that the party is coming up with that position, that no judgment has been delivered yet. What should the Supreme Court do? It's serious enough to warrant an in-house investigation, interrogation, evaluation. Supreme Court needs to look at it again. Is it true? And if it is true, then the Supreme Court will simply impress everybody by saying, it is true. In the pressures we have been under, this is what we are saying. Too many cases are coming up, like the Chief Justice lamented. It's too much, and then the leader of the body of senior advocates also lamented on Monday. Too many cases are coming up. The pressure is too much, so we actually omitted this. But if it's not true, then the Supreme Court will have to, blow by blow, line upon line, precept on precept, explain that the judgment has been delivered.
Well, senior advocates. Well, senior advocates, wherever you turn, it appears that there is dissatisfaction, and the judiciary appears to still be on trial. Still on the comment by the CJN, about how justices should focus on the law rather than on emotion or sentiment. Wherever you turn in our political practice and electioneering especially, there is emotion. So when you look at the preponderance of judgments that have come out, particularly in the last general election on governorship election cases, where has the emotion gone? In which favor has it gone? On the part of the people or on the politicians?
First of all, you say the judiciary is on trial. True. I will enlarge that to include democracy. Democracy is on trial in Nigeria. The legislature is on trial with those humongous budgets and those 160 million naira legislature SUVs. The executive is on trial with an overbloated executive arm of government and little to show for it. The whole country is on trial, and not just the judiciary. But it is good that everybody should be on trial. The good book, the Bible says that work out your own salvation with fear and trembling. So let every arm of government work out our own salvation with fear and trembling. Let's look inwards. Let us improve. We need to improve, and the only way we can improve is to be on trial.
We need to wrap up, but just one more thing before you go. You know, you did talk about proof. They should bring proof to you if there's any such thing. Have you seen this document that came through from the ICPC, the 2022 Corruption Index, where they spoke about corruption in the judiciary? Therein, they did say that lawyers are most responsible for offering bribes for favorable judgments. Litigants followed with 21.96%. Court staff, that's the clerks, registrars, 21.54%. Judges, 16.88%. And government MDAs, 7.37%. It goes on. There's several other documents there, but they then say that the total amount of money reported by the justice sector respondents as corruptly demanded, offered, and paid between 2018 and 20 was about 9.457 billion naira.
It's not a laughing matter. It's not a laughing matter. It was led by a professor of law who is also a senior advocate. And if an organization led by Bolaji Onwasanoye, a professor of law, senior advocate of Nigeria, and as credible as the ICPC is, to say these things, then we cannot lightly esteem what they have said. We should not lightly esteem them. Of course, I don't have independent figures, but I think that it is a matter that should be of concern to both the bar and the bench, and indeed the entire nation.
We need to anchor at that point. I'm sure we'll have further conversations of this matter moving forward, because we all want a system that works really well.
Absolutely.
Mr. Kaza Kariwe, Senior Advocate of Nigeria, former First Vice President of the NBA and convener of We the People. Always a pleasure to have you on.
Always glad to be on the #1 station and program. Thank you.
All right. We're back in just a moment, and that will be from Lagos with Kaide and Bookie.